All right. Good morning, everybody. Welcome to the Angus and Terry Attorney Hour with Colin and Ann. Subject matter is water intrusion. It's kind of going to dovetail nicely for those that were in attendance at the CACM luncheon last week. And it's also going to help our project management team develop a system to audit our communities that are most at risk for multi-unit floods and water intrusion claims and things like that, in an effort to help our clients avoid higher insurance premiums. I'm going to make Ann, and first I got to figure out how to do it. It shouldn't be too hard. Ann, add as co-host. Colin, for good measure, I will add you as well. And before we begin, this is being recorded. So if you have, Ann, Colin, if you have anything that you'd like to add about how this recording can and can't be used, please feel free.
Yeah. So as with any of our legal hours, this is meant for informational purposes only. This is not meant for specific legal advice to your communities. If you need assistance for any of your communities, please reach out to us so that we can review the documents and then provide us specific advice for your association.
I would also point out at this point, Ann, that Paul started the recording after my joke, in which case it was reflective of the fact that he didn't like that joke. So
it was hilarious. We lost about half of the attendees because they laughed themselves to death. So.
Let me go ahead and share my screen.
And I'm going to mute myself.
Can you all see that? Is it flashing? Because it's flashing on my screen.
Yeah, it's flashing for us. Yeah.
How do I do that?
Yeah.
Okay. There we go. Okay. Can you all see that okay?
Yep.
All right. Sounds good. Okay. Well, hello, everyone. My name is Anna Cunha. For those who don't know me, I'm a partner at Angus and Terry. I'm here with my partner, Colin McCarthy, who some of you know and are working with. For those of you that are not familiar with Angus and Terry, we are a law firm that specializes in common interest development law. We've been doing this for over 35 years, and we serve associations of all types and sizes all over California, Ohio, and also Florida. Many of you are familiar with our general counsel department. We assist with advising associations of basically how to stay out of trouble, but also assist with interpreting governing documents, amending governing documents, preparing policies, assist with collections related issues. We also offer services as inspector of elections for those associations we're not general counsel to. And also provide board member and membership trainings. And for those associations, new association clients that don't already have a general counsel or want to switch their general counsel, we are offering special rates for those associations for the first 12 months, and also a complimentary board training via Zoom. So that's very popular and very helpful for many of your boards. We also have a construction defect department headed by my partner, Jordan O'Brien. If you have associations that are under 10 years old and they have not yet done their due diligence inspection, please reach out. We can schedule one for you with one of our architects for free. And this is for associations with significant maintenance responsibilities for buildings such as condominiums, and then also attached townhomes, which we'll also be talking about today. If you need proposals for any general counsel or construction defect site walkthrough or any other type of work, please feel free to contact Julie Mauser, our managing partner. This is her cell phone number, which she has authorized me to share. You can text her or call her during decent, not even business hours, but regular hours. And then also Ivy Vu, who couldn't be here today. Many of you know her. She can help get proposals to you. There's her cell phone number and her email and you can ask her for proposals or ask if there's anything that we can assist with, let them know. So today, as Paul mentioned, we'll be talking about the best practices for handling water intrusion issues, which is pretty timely given we got a little bit of rain the other day. Hopefully we'll get more of it. And so this may become a bigger issue the next few months. But I know a lot of you have associations with older systems, and plumbing backups are a constant problem. So we hope this will be helpful. Again, if you need specific assistance with one of your associations and they don't already have general counsel, or our office is their general counsel, please reach out to us for assistance with that. So just starting out, just a big overview. One of the initial things to look at and consider when dealing with leaks, backups, is whether you're dealing with a community that's new versus old, meaning an under 10 community, because there are different ways of looking at it, and financial sources that may be available for a community that's under 10 years old and maybe dealing with a possible construction defect. So many of you know water just travels to the point of least resistance. They will go through walls, floors, windows, roofs, and they are, some are related to weather, and just the components getting old and not properly working to keep the water out. But sometimes it's a sign of a larger problem with the system. So keep in mind, work with legal counsel if you are dealing with a possible construction defect and your community is under 10 years old. You may be able to get the builder to address these issues, and there's statute of limitations typically that apply. And plumbing is a little bit shorter, but sometimes the lawyer can argue that it's for an issue that has a longer statute of limitations. Another initial consideration is what type of community you're dealing with. As you know, if we're dealing with a detached single-family home community, the association and management company is less likely to get involved in dealing with the repairs because the association is not usually responsible for maintaining and repairing the residences. Condominiums, on the other hand, you will likely be involved because it involves water. If it's through involving multiple units, it'll definitely involve the common area, the area between the two floors or between walls of two units, and the association has to get involved, even if these are owner-caused leaks or backups, because of the fact that it impacts the common areas. You do need to be involved. And then when we're talking about attached PUDs or townhomes, it's a little bit more complicated. It really depends mainly on whether the association is responsible for any of the components that are affected by the leak or the backup. So a lot of times it's also disputing certain things because, for example, the roof, there's certain parts of the roof that the association is responsible for, and then other parts the owner is responsible for. So it usually requires a careful review of the CC&Rs, or arguing the default provisions of the civil code, which we'll discuss in a little bit. So this is our general recommended steps or game plan for dealing with these, and we'll have a recap at the end of these steps. But this is what we'll be talking about today, Colin and I. And in addition to these steps, Colin will also talk about some things that the association can do to best prepare the association for these leaks and backups, and make sure that the association is set up for future issues. And then also we'll be talking about briefly how insurance comes into play in all this. Oh my God, excuse me. Okay, so first things first, take water intrusion issues. I say mold. I sometimes call it the M word because we need to be careful when in your written correspondence and not filling it up with the M word as much as possible. Talk about it as water damage, water intrusion, and you'll see homeowners doing the same thing. They'll usually put black mold everywhere in their emails. But any potential situation where mold can be involved, take it very seriously from the start, regardless of who is complaining about the issue. But be extra careful when you're dealing with individuals that are in the special categories, people who are sick, elderly, children, pregnant residents, and of course, our favorite, the litigious homeowners, those threatening lawsuits. If you see homeowners saying they'll be consulting with legal counsel, be very alert to that. If you see them copying or BCC or carbon copying attorneys in their emails, especially if it's a lawyer that is a personal injury lawyer, you need to make sure that the association's legal counsel is involved already. So for any of these, you need to be very, very careful and sometimes to limit liability, we may advise the association to handle things a little differently because of the person we're dealing with or the people we're dealing with. But the overall goal is to mitigate potential liability, to minimize potential damages. So I know some boards are very much into just interpreting strictly what the CC&Rs and civil code says, and they want to do the minimal amount and not be involved in these. But as you all know, something that could be about a $5,000 unit repair can blow up to hundreds of and thousands of dollars of claims for personal injuries, based on something that could have been dealt with and put to bed much earlier on. So one of the other things to do that you can do now is pre-select your vendors. Talk with your senior managers, your colleagues. Collins probably has a list of preferred vendors that it likes to work with when dealing with water intrusion issues. Your industrial hygienist, the mold remediation contractor, plumber, roofer. These are some of the typical vendors that you will need. You should have ready to call, properly vetted already with insurance, licensed, and good with working with associations and management companies, because as you know, some of these companies, just how they word things, how they document things could impact a lot of things down the line. It's good to work with vendors who are aware they're not supposed to be having phone and email discussions or lengthy discussions with a homeowner, that it's supposed to be very minimal, only about scheduling. That they're not supposed to be providing reports or oral assessments to homeowners when they are on site. These are the kind of things that you should discuss with if you're working with a new vendor. And if you have one that you've been working with for a while, make sure that there hasn't been any issues with them over communicating things with the homeowners. Keep in mind that once you a homeowner reports or you become aware of a leak or water intrusion issue, you need to alert the board that you will be needing them to make quick decisions. So you need to make sure they know that they should be checking their emails, or if the best way to reach them is by phone or text, you have that ready, because there will be a lot of decisions that need to be made quickly. Usually what's best is if the board is okay with designating one or two board members to take the lead, kind of like a little forming a committee so that you're only coordinating these things with those two, or maybe give them a certain dollar amount authorization to approve emergency repairs. That would be really useful. And just a reminder, typically board decisions should be made at an open meeting unless it's one of the categories that could be discussed in executive session. You need 4 days notice for a regular meeting. And these could be, I guess, specially set meetings. Even so, if the board meets quarterly or every month, let them know that you need them to make decisions sooner than their next regular meeting. So they'll need to specially set either a regular meeting or schedule an emergency meeting, which doesn't require notice. And when you're dealing with a leak or a backup, that usually is justification for holding an emergency meeting. So emergency meetings can be held by phone conference or Zoom, so that the board can take a vote. Email is fine, but you will need unanimous consent if it's through email. And if the board needs to hash things out, or some don't agree and you need to take a vote, that should be done by phone or Zoom and then recorded at the next regular meeting minutes is what you do. Again, the goal is to remediate as soon as possible. It takes time to figure out whether an insurance claim is going to be opened, who's responsible for what. You should be advising your boards to just, if we're talking about a community where part of the common area or a component that the association maintains is involved, then make sure the board is aware you need to move quickly and handle the mold remediation as soon as possible. Obviously, this is not something you would do in a single family community where someone, if they even do report a water event in their home, you wouldn't get involved there. But if we're talking about a townhome or condominium and the cause of the leak is a component maintained by the association, or if part of the common area is involved, the water traveled between two different units, then you would want to get involved in the remediation. And in doing this, make sure that homeowners are aware, and it's in writing, an email is fine, that the association takes these things seriously. It's going to schedule the mold remediation, and later on, once the cause or the responsible party has been determined, then they'll be you'll reimburse them, so that they're aware in case this is a situation where it's a homeowner caused leak or a backup. They're aware that this is not something the association is doing, and then they'll never be responsible for paying for the costs. All right, Colin, I think this one's yours. I think you're on mute. Colin, you're on mute.
Sorry, I thought I clicked it off. And you want to hand control over to me or just keep flipping?
I can flip for you.
All right, super. I just would emphasize really what Ann said there in terms of don't wait to remediate. Don't assume that that the homeowner is going to remediate, or if there's counsel involved, don't wait, because you don't know the source of the leak or why. We're going to talk in a little bit about sourcing the leaks. So just get it done, and as long as you are advising them that you are going to hold them responsible if it's their responsibility, you are mitigating the damages. I have one right now where that did not get done, and the unit was entirely black. And it's a combination of factors. There's some common area involvement, but there was also some shower repairs that didn't go right. And there's counsel involved, and it was delayed. So just do not delay that, and especially if there's counsel involved. on the other side. You will want to remediate it, and you can take care of it later at the IDR or the mediation. Yes, Paul.
Can I ask everybody to turn off their cameras, and then later, if you have a question, to turn your camera back on? We're getting a lot of issues with freezing in this presentation, at least in the Hercules office. So maybe a bandwidth issue. That's all. Okay.
All right. Before I jump into this stuff, I did want to share another joke if people are willing to listen. There's an attorney, his assistant, and a paralegal, and they're all walking to lunch. And on the way to lunch, they discover a magic bottle, the lamp. And so they rub the lamp, and out comes the genie. And the genie sees the three of them and says, "Wow, well, you get 3 wishes. Since there's 3 of you, I'll give you each 1 wish." And the secretary says, "Oh, I wish I was at the beach drinking pina coladas with my personal masseuse." And poof, she was gone. And then the paralegal says, "Oh, I wish I was on my speedboat with my family and we were out enjoying nature." Poof, she was gone. And the genie looks at the attorney and says, what would you like? He goes, "I want those both back in my office after lunch."
Ha ha ha.
All right.
I didn't even get to hear it because you froze again. So
Did I?
Right in the middle of the joke, you froze.
Oh,
So
man.
I'll take an act of faith that it was hilarious. So.
Okay. All right. So do you have to relocate the individual or the residents affected? Well, of course, it depends on the facts. You have to look at the CC&Rs. You'll want to check with your attorneys to interpret those languages for you. They usually are silent, don't say anything, or if they may say it's not required, but there is a civil code that says when it's association responsibility, the cost of relocation is to be borne by the resident, or by the owner of the separate interest. And so that would imply that if it was owner fault, that you would also have them be responsible for the costs of there if they were the at fault party. So consider that as part of this issue. Next slide, please. Thanks.
Just add some examples of situations I've seen where it totally made sense for the association to offer relocation, even though not required, is when the cause of the leak or the backup was a component that the association is required to maintain, and maybe they had a vendor work on it, and it caused more problems. So basically, it looks bad. It looks like it's the association's fault, and you're dealing with a family with kids and all these things. So that may be a situation that's warranted. Also, sometimes there's a little bit of miscommunication between the owner, management, the board, and there appears to be a delay that was caused by the association. So I think under the certain circumstances, it made sense, and we had recommended to the association to offer to pay for a couple of days, even a week of relocation. I would also add, if the association is kind enough to offer this, make sure you as managers are monitoring the relocation, because I've had it where they left it to the homeowner to book the hotel and they didn't realize that 4 months later, this person is still at the Four Seasons, and then they were going to bill it back to the HOA, and nobody had any idea that the repairs weren't done yet. So you got to keep close track of these if it is offered by the association.
Yeah, so Anne's saying that even if you can pin the responsibility on the owner, it's not always the right thing to do, depending on the particular situation. So before you try and pin it on somebody, or talk to your attorneys, or at least your board, about the etiology of how that leak came about and the board's response to it. Okay, after the remediation is done with your licensed company, and by the way, it takes a while to get permits for the remediation. So it's not going to, in terms of acting quickly, you'll want to act as quickly as you can, because sometimes the permits take a long time. If the building is older, they may have to get an asbestos permit as well, because they don't know what they're going to uncover when they start their remediation. So that's another reason to start that process as soon as you can, because and just so you know, the damages that are going to be claimed are I was out of my residence, I couldn't rent this thing for a while, and as such, I lost all sorts of money, and it's your fault. So the sooner you get it remediated, the sooner you can get people back into the residence, the separate interest. And one of the things you really should do, and the remediation company will do this for you, is to get the remediation or the clearance testing after the remediation, but before you start any kind of work. And they will do that, and I'm having one done, I think today, in one of my cases, to make sure that we get all of the quote unquote toxic, potentially biological agents out or to habitable levels. So, and yeah, you should think of this as kind of an insurance policy that it's been remediated. So, and that is in conjunction with the next step, which would be to start figuring out, where did that leak come from? And now you need to get an expert to help you with this, a plumber or an architect or some expert who can help you identify the source of the leak if it's not like readily apparent, like a leaking, and you'll want to document it. I have one where there's like a leaking water heater. You could see a video where there's a leaking water heater, and that led to all of the issues. So, but you're going to want to have an expert to document it so that the board can rely on that in terms of making their decisions for responsibility. And also, it's just practical. If you don't identify the source of the leak, you're just going to be doing that again, and you're going to be remediating again. So you got to identify it and you got to stop it. There could be situations where there are multiple sources of water intrusion causing the biological agents. As I indicated in mine, there's one where it's potentially at the windows and at the deck, as well as a bad shower. So those would be overlap of responsibility. And so the question in that case is how do we apportion it? And so we're getting experts to analyze that. So yeah, possible sources of the leaks are external through the windows, the doors, the building exterior, the roof, internal plumbing lines, HVAC, toilet, wax rings. I have one for that. Tub and shower caulking. Also, the water heater is one, depending on where it's located. You get a licensed vendor to do it, as indicated. They would, you'll want to confirm the source of the leak orally so that you understand exactly what it is before you put it in writing. You're not telling anybody not to not tell the truth or anything like that, but if you want to be clear on whose responsibility it is before that's put in writing, and so you can kind of ask them questions that they maybe didn't think of that might redirect them to other potential sources that would be more equitable. And then once you have identified all of the sources of the leaks, you want that vendor to document it and be as conclusive as they can be, and leave out things like possible sources of intrusion here and things like that, because that's just going to give a later attorney fodder for why the association should be responsible for all of those costs that you just spent. And the remediation is not cheap either. So definitely be careful at this stage. And again, working with counsel is a good idea during these processes. Yeah, so after you've determined the source of the leak, you can look to those documents and your lawyers, your trusty lawyers, to figure out, all right, who is responsible for this, and what provisions in the GovDocs and codes can we use to get reimbursement for these costs? Can we include, if they refuse to pay attorney's fees, et cetera, for the costs and for the reimbursements? Yeah, and then even if you're not responsible for the interior repairs, you're going to want to make sure that they occur. especially if there's insurance money involved. So if you're getting insurance to pay for some of these repairs, you're going to want to make sure that they use those insurance monies to proceed with the repairs that they're required to do. And usually the CCNRs will have provisions in there that require them. You can just utilize you're required to maintain the interior of your unit provisions in conjunction with the disbursement. But we usually like to recommend that you get an agreement from them that they will use these proceeds as required. So you have a double kind of enforcement mechanism against them, both with a contractual agreement that they will do it, and then also the CCNRs that say that they have to do it anyways. And so that way you're putting them on notice and obligating them to do the repairs with that insurance money.
Can I just add, Colin, for the first bullet point, I have seen some plumbing vendors who do good work, but go the extra mile of like putting in the invoice who's responsible for the repair of the component. It would say something like a failure was found in the exclusive use portion of the piping, which the homeowner is responsible for, or something along those lines, which is to help the association, who hired them, which is great, but it sometimes is not even consistent with what the governing documents say. So just be aware, just because the plumber's invoice says the homeowner's responsible for it, it doesn't mean that's really the case. So check with legal on that.
Yeah, because you know what? They're not lawyers; they're plumbers, and they're good, but they're out of their lane in that one. It's a team effort. All right, so determining the responsibility. How do we do this? How do we lawyers do this? Well, we check the CCNRs. We check the statutes if in the absence of provisions in the CCNRs. But the CCNRs usually will have allocations for responsibility. Sometimes they will have what we call the Marie Antoinette clause. And this is not because the association can have their cake and eat it too, although that is a potential outcome of this provision. It's actually named after the case that decided it. There was a homeowners association called the Marie Antoinette Association, which is an interesting place to live, I wonder. So yeah, basically this one says that the court upheld the ability of the association to have the owner replace and repair property in that unit if they were the ones that were responsible for it, or if the board and association was not grossly negligent in doing that. So that's a pretty good provision. You want one of those in your governing docs if you don't have one. And that will lead to the next kind of segue to it in terms of, I think we're going to talk about things that you could do. Maybe that's much later, I don't know. But we'll talk later about, amending your governing documents. So the civil code allocates responsibility in the absence of provisions in your declaration, as you see here up on the screen. So it's the common area if there's nothing in the governing documents for the association. If it's not in the declaration, the owner is responsible for the separate interest repair, and if it's not in the declaration, the owner of each separate interest is responsible for exclusive use common area that's appurtenant to that separate interest, while the association is responsible for repairing and replacing the exclusive use common area. So it's split there. The maintenance and repair is split for exclusive use in the absence of provisions in your governing docs. Most likely your governing documents will have something and this provision won't be necessary. But if they're particularly old documents or they don't have any provisions, then this statute would substitute for that.
The other thing I would also add, and again, keeping in mind the goal is to mitigate damages and prevent the situation from blowing up into something bigger. For some associations that have this Marie Antoinette clause, which basically says the homeowner is responsible for the unit repairs, even if the leak or the damage was caused by a component that's maintained by the association. Even if the association was negligent, as long as they were not grossly negligent. So even if an association has this clause which protects the association, in some situation, it still may make sense. Work with legal counsel. Some situations still make sense for the association to take charge of some of the remediation or some of the basic repairs to a unit. If it may mean that the association would not get dragged into a big lawsuit with that homeowner. So,
Yeah, and just so you know, that grossly negligence is kind of like reckless. It's not just an absence of due care. It's recklessly not caring about the property or the situation. So that would be something like where you were on notice of a condition and didn't take any steps for like 3 or 4 years, and then the damage happened. There are scenarios where you know that something's going to happen, but kind of ignore it. And then it's not intentionally malicious. You're not trying to harm somebody, but you're certainly not acting with due care. And it's a slightly higher standard than due care. When to perform the repairs? Well, you don't want to do it until you understand the causation, as we talked about, and that causation is documented. And then you have to understand the affected areas of the repair, the scale of the damage, what issues are going to involve the homeowner, whether or not they're going to be involved in the repair or not. And then if there were mold problems, if those mold have been remediated and are not going to come back. And then also you got to know whether or not you could pay for it or where you're going to pay for it, either through insurance or through reserves or through reimbursement assessments or some combination of those three. And then the issue of the deductible comes up if it's insurance is involved and who pays for that. And that's in your governing documents sometimes not. So you'll have to look at that issue as well. Other considerations, should you tender it? As you know, some of the insurance companies are now denying or not renewing based on the excessive number of claims. And if you were in attendance at that presentation that we did last week, is that you heard the insurance brokers talk about how just the sheer number of claims on a particular development may give an indication to the insurance company that there's a systemic problem going on at the unit, and that it's time, and they're just going to see more and more claims, so they don't renew. And that makes it more challenging. So it shouldn't automatically be a tender to the insurance carrier. You should look at all of the totality of the circumstances, the scope of the damages, whether or not you can reimburse, assess, and whether or not it's going to impact your insurance. And you can reach out to your broker and ask them. So have your board rely on those experts. Then we're going to talk about this in a little more detail, but yeah, as you emerge from this process, you got to take a look. Did those governing documents help or hurt the association in the process? And if they didn't help, and if they hurt, then you're going to want to take a strong, hard look at whether or not you want to do a spot amendment and change the insurance and claims handling and water damage provisions in your governing docs to make it a little more favorable to the association. So legal preventative measures. These are the things that you can do on a forward-going basis. You can change and look at your governing documents where these issues come up. A lot of CC&Rs will have provisions where you can't reimburse somebody if it's covered by insurance. So if it's paid for by insurance, you can't assess them. So you want to see if you can get rid of provisions like that so that you can assess them, even if it was paid for by insurance, or if you choose not to submit to an insurance claim. And then in the maintenance provisions, there's a lot of provisions that, again, that says that cost of which is not covered by insurance, the association's obligations or the owner, even if the owner caused it, the only time that you can get them obligated is when it's not covered by insurance. So you want to look at those provisions in conjunction with the walls in and walls out. Whether if you're in a condominium, does your association cover everything inside? If so, you may want to push that to walls out. Then you also want to consider the minimums that are required for third party. If you're going to take a look at your insurance provisions, you'll want to take that opportunity to protect the board from personal liability and require that they purchase liability and directors and officers insurance with the statutory minimums. And that depends on the size of your association. If it's got 100 or more separate interests, it's $3 million in liability insurance to protect the owners, and $1 million to protect the directors. D&O, it's like 500,000 and $1 million on that split. Other things that the insurance provisions in your CC&Rs you can work with are deductible allocations among the owners and associations and respective insurance companies for fault, like when there's a fault implicated and whose responsibility is, when there's no fault, when there's two insurance provisions on the loss, you can allocate among them. If there's no determinable source of, you can try to, through your governing documents and or rules, allocate responsibility for deductibles among those provisions. You can also do the same thing with claims procedures in terms of directing. You don't want automatically to have the association be the first place that they look for. Some provisions even say that the association's insurance will be primary if there's two coverages on the loss, and that isn't necessarily something that you'd want. You'd want to make them co-responsible, or if it's something that you can do, you want to hoist that off on the owners to make them responsible for it and not the association. And in conjunction with that, you also want to look at what requirements, the HO6 requirements, the governing document provisions have for your owners. What do the CC&R say about what they're responsible for? And can we make them responsible for more through the governing documents? If you do the amendments, you're going to have to consider, it will have to go to a vote. And then sometimes there's supermajority requirements if you change insurance. And lender approvals are sometimes required. The other thing is that it's sometimes hard to get these things through because members are not, as you guys are so thrilled right now to be listening to us discuss insurance, the members are so similarly thrilled to be listening to or having to read through an insurance amendment that they're just not going to care about because it's most likely going to affect them in a negative way. So at least immediately. So the sales of that amendment is going to take a little bit of town hall movement and things like that. And you can always petition the court if you don't get enough votes, but you get a certain threshold of votes for a quorum. You can try and petition the court to reduce or lower that quorum. And we've done that successfully. I just did that a month ago for an association, not with respect to an insurance amendment, but you can still do it. So if the CC&R amendment is too difficult, then you might want to consider a rule change instead. You can do some of those claims handling deductibles through rule changes as long as they don't contradict what's in the governing documents. So consider that as well.
Yeah, some of you are familiar with a water loss policy, which talks about homeowners reporting and how the association will handle repairs and remediation. That's usually helpful for associations, and that's something that can be done without amending CCNRs, in addition to rules regarding claims handling and payment of deductible. So just a recap of those key steps that we talked about. Again, first and foremost, take mold or potential mold complaints seriously and move quickly. Make sure your staff is aware of that, and if you have assistants that can handle immediate responses, these are things that need to move quickly. So sometimes require same day response to emails and inquiries, and getting proposals quickly in a matter within a day or so. You need to move quickly and then work towards investigating the cause as soon as possible. Pre-select your vendors. That's something you can do now before the rainy season really hits. And also figure out, make sure these are vendors that will, that provides good documentation in case later on this turns into litigation. You have all your ducks in a row and you can fight a claim from a homeowner. And make sure that documentation that you did things right and timely and promptly. Have a plan for prompt board decisions. Make sure they're aware. The board is aware that their involvement and immediate quick decisions is needed in these types of situations. Remediate ASAP. Worry about the money later. That's going to, I think that's probably the most important thing here, because the key is to get the unit or the residents back into a habitable condition as soon as possible. So not fully repaired, you don't have to put floors and all those things, but at least it's habitable, and they can't claim that they can't claim loss of use, that they couldn't move back in because the association was dragging its feet on this.
That's actually saving the association money.
Yeah, it seems expensive. Sometimes the boards will fight you on this. They're going to say, well, no, let the homeowner file a claim with their insurance and let's deal with it like they have to do it themselves. Again, if it involves the common area or a component maintained by the association, it's in the association's best interest to handle the remediation portion and do it as soon as possible, even before it figures out if it wants to file claims and all of that. It's just best for everyone. Get legal to assist you with pushing the board on that if they're fighting you back. As far as relocation, in most situations, it's not required for the association to do that, but in some situations, it makes the most sense to do that, to offer it. Perform clearance testing after the remediation, not before, because you already know what the results will be before remediation, and there's no point to have something like that in the association's written records. Identify the source of water and moisture and correct it. You don't want to be putting walls back and floors back and then having the leak just come back. So that's very important to do. And then determine responsibility for repairs. If the documents are unclear, work with legal to do that. And even if it turns out the association isn't responsible for the repairs, if it involves common area components, make sure to monitor the repairs, make sure it's getting done. If the homeowner is dragging their feet on it and refusing to make the repairs that they're required to do, most CCNRs have a provision that allows the HOA to handle repairs. Again, that's not most boards don't want to get involved if they don't have to. sometimes in some situations, it's best to just get it done and then bill the homeowner back. That's something that should be analyzed on a case-by-case basis and with legal involved to determine whether that's the best thing to do under the circumstances. And with that, here's our contact information. We'll take questions. If you have any specifically related to leaks and water intrusion, I think we got one from Dean. And then after that, we can open it up to general questions if we have 9 minutes. So let's see. Colin, do you have Dean's question handy? Or Dean, do you want to?
Yeah, I can read it. Hang on. Sarah had one on the 4710 issue for the signs. I can handle that one real quick. She did get first in order on that one. Right, Sarah? You asked one on the Google Doc.
Yeah, just, they have a restriction against all signs other than real estate, but somebody wanted to know if that was
That is,
okay.
governing documents can't prohibit posting of any non-commercial signs. So that's under 4710. So non-commercial signs means poster, flag, banner, any kind of
Political.
First Amendment.
On
Political.
their property. So if it's in
Their
their
own
property,
property,
obviously they can, but yeah, in their property.
So,
Okay.
So they can, his wife's running for mayor, so they can post her sign.
yes.
They
But
can,
they can't be bigger than 15 square feet. Just so you know.
Okay,
And they cannot have balloons on them. So
okay,
you could prohibit balloons.
thank you.
You're welcome. You want me to read the one from Dean? Yeah, hang on, I'll read it. Dean's question is, in the event of a multi-unit flood caused by a component which is the responsibility of one of the units, i.e. a toilet, after the HOA has done emergency water remediation, removing walls, cabinets, flooring, etc., what is your opinion concerning who should build back the units? Leave it to the individual insurance policies or take charge of the build back and go back to the liability carrier for the unit at fault? Anne, did you want to?
yeah. So if there's clear documentation, this is not the leak was not caused by the association, and the association took care of any water damage, potential mold in the common areas like behind the walls, through floors. Most likely the association isn't responsible for building back the unit. And then if they have that clause, the Marie Antoinette clause, that'll help push owners, even the ones who are not at fault, to push them to repair their own unit. And if you don't have anything in your governing documents or nothing about that, the civil code provision that Colin talked about, where it says the association is responsible for repairing the common areas, homeowners are responsible for repairing their units. That's basically says they're responsible for. So, but the association should be involved as far as monitoring and making sure that the homeowners do repair their unit. If you need to have, send letters citing to the governing documents or the civil code, that's probably best done by legal counsel. But most likely the association is not responsible for actually doing the repairs, but it should be monitoring and making sure that the owners are doing that. Sometimes leaving it open could, I've had one where the homeowner just didn't want to do anything, and they kept the ceiling open and exposed. And every time there was a mold reading, it would basically, show existence of mold because it wasn't closed. The ceiling wasn't closed. And in that situation, we urged the association to close it back up, try to get access to the unit to close it up so that the common area isn't exposed, just exposed and out in the open. So the association has to remain involved. But as far as building back, putting the carpets back and painting and putting the components back, probably they're probably not required to do that. Any follow-up to that, Dean, or any other questions from anyone?
No, I was just that was what I thought you would say, but I wanted confirmation.
Okay. We have 4
All
minutes.
right.
No? All right. Well, you know where to find us. Yeah, good luck to all of you. When it starts raining again, roofs start leaking, gutters start leaking, windows start leaking, and you need assistance, let us know. If you have a newer community, the roof is leaking, windows are leaking, most likely it's a construction defect. So also let us know and we'd be happy to assist.
Line up those vendors now.
Yeah.
All right. Thank you so much, Ann, Colin.
Thank
This was
you.
wonderful.
Thank
We
you,
really
Thank you,
appreciate it.
Colin.
You're
All
welcome.
right. Bye-bye, everybody.
Have a good day, everyone. Bye-bye.
Bye.